get it to turn it on. Yes, that was
do. So I'd like to call population health to order. And I would like to ask the clerk to please open up the vote, call the roll, please. Okay, I would ask for you to close the roll and call the roll.
Madam Chair Lady, you have 9 members present. You have a quorum.
Okay, thank you. Thank you, Clerk. This time, we would like to welcome everyone, our visitors out there. To say welcome to all of our physicians. It's Physician Day on the Hill. And so thank you all for being here. And at this time, I want to ask any of our members if they've got any personal orders or announcements. Did you have something?
Thank you, Chair Lady. Yes, but you took care of that for me with the TMA Day on the Hill. I appreciate with all the white coats out there. Welcome, everybody.
Well, you know, I have a few in my family, so I can't forget my white coats out there. So thank you all. Okay, again, welcome to Population Health Subcommittee, and today is March 4th, 2025. So we're going to start with our agenda today. We have House Bill 0026 has been taken off notice. Our second bill for today is House Bill 1156 by Representative Lynn. Okay, do I have a motion? Okay, you have a motion and a second, and are there any amendments?
There is an amendment.
Okay, do you have that
for
number?
reminding me. Yes, I do. 4012.
That's correct. That's what I
Okay.
have.
All
Okay. Your bill is properly before us, so please proceed with a brief description of your bill. That's right. I forgot, because we've got to have a motion and a second on your amendment. Sorry about that. Okay, so we got a motion and a second, and so we will add amendment 00412 to your bill. So we're now on the amendment.
Thank you, Madam Chairman. This bill removes the unconstitutional code telling parents it's their responsibility to follow the CDC or AAP vaccination schedule.
Okay, hold on one second.
Oh, sure.
All in favor of adding her amendment, say aye. All those opposed? Okay, you're good. Sorry, proceed.
Basically, Tennessee law is quite unique. Tennessee law mandates that parents follow the CDC or American Academy of Pediatrics vaccination schedules. Even though the CDC schedule is a recommendation, the American Academy of Pediatrics schedule is a recommendation. And even though when children start school, daycare, preschool, when they start those schools, those schools have a mandate to start school that you have to have your vaccinations. So this law was found to be unconstitutional way back in 1905. It's called the non-delegation doctrine. And what that means is Tennessee, in our law, we have delegated the authority to the CDC to set our mandate upon parents about vaccinating their children. No other state does that. In fact, it probably doesn't make any difference in Tennessee because Tennessee is right in the middle of the pack when it comes to children being vaccinated. When they start school, we can see what Tennessee is right in the middle of the pack. And other states don't take the CDC's recommendation and say, this is what you have to do. Now, it's called non-delegation because we don't have any control over that schedule. The CDC makes up that schedule. So regardless of what the CDC says, recommends, doesn't recommend, Tennessee is not taking an active role in those recommendations. And that's why that non-delegation was found to be unconstitutional. And as I said, no other state does it. When children start daycare, preschool, school, they have to be vaccinated. There are, of course, there is a medical exemption, there's a religious exemption that parents can apply for. But basically, to attend school in Tennessee, you have to be vaccinated. So all we're trying to do is remove this very unique because I can't find another state that has the same law, unconstitutional provision from Tennessee law. And I realize that there's some concern that vaccination rates may decline, but quite honestly, parents take their babies to the pediatrician or the clinic, and that recommendation to receive vaccines is made to them. It's made to them in the hospital when their baby is born. And this law, removing this law, will not change that. That is the professional opinion of that doctor who when that baby is born, that baby, mom and dad should have these vaccines because it's just safer. All of that. All we're saying is, parents, you're not going to be charged with a misdemeanor because you're not following this law. And this law, too, is something that gets jammed up in divorces because our law says you have to follow the CDC's vaccine schedule. And let's say mom hasn't, dad hasn't, whatever, it gets jammed up in divorces and they can make this claim. But this has already been found. This non-delegation has been found to be unconstitutional. And therefore, that's why we're seeking to remove it from the law, to remove any confusion.
Okay, we've all heard a description of House Bill 1156. Is there any questions and all for the sponsor? Who's first? Who's first? Okay, Chairman Terry.
Thank you. Can we go out of session and have a legal opinion on something that was said?
Absolutely. Let's go out of session.
I want exactly what was said, sir.
Okay, thank you. You have to say your name. And,
Oh, Heather Asbell, Office Legal Services.
right. Thank you. So I guess the question that I have is, it was said that our current statute is unconstitutional. Is that your opinion, that the current statute is unconstitutional?
So the bill addresses, is deleting TCA 3710-401A and section 402 and 403. To my knowledge, those sections are not unconstitutional, to my knowledge.
Right. And then second question, it was discussed about penalties for parents. Are we going to be removing penalties or what? What exactly?
So in current law, talking about 3710-401A, it talks about its responsibility of the parent to vaccinate their child. And specifically in TCA 3710-403, it says no parent, legal guardian shall be criminally prosecuted nor civilly liable for failure to comply with the provisions of this part. So there's not, a parent would not be civilly liable or criminally prosecuted for not abiding by current law with the responsibility of vaccinating your child.
So what you're saying, it's not unconstitutional and currently parents aren't penalized for violating current law?
Yes, to my knowledge, it's not been held unconstitutional, and currently you cannot be prosecuted civilly or criminally prosecuted for not complying.
Thank you.
Okay, while we're out of session, does anyone else have a question for legal? Okay, we'll go back into session. And I have Chairman Clemens. You still have a question? Okay, okay. So let me ask Representative Lynn, do you have, let me recognize Representative Lynn before Chairman Kumar asks his questions.
I do. In 1905, the Supreme Court's Jacobson's decision said that vaccine mandates are use of police power, and it's the non-delegation doctrine that this violates. Tennessee cannot delegate our decision-making to another authority like the CDC or anything like that. We can't delegate that away from the legislature, which in effect is what we have done. And also, because this is in the law, and if a parent doesn't do this, it can be said that they are in violation of the law. A divorce claim, a custody claim can easily be made saying, look, the law says this, and that's not been done. So it can be said. Now, no one's going to go and arrest them and lock them up. That is true. But still, it can be used against a parent. And sometimes parents could even be just a little behind for one reason or another on vaccinating their children. It's, I mean, I have a grandson with type 1 diabetes. And his mama, he got it when he was 1 year old. So his mother put the brakes on things for quite a while due to that illness until she felt stable and confident in caring for an infant with type 1 diabetes. Very, very difficult thing to do. And Madam Chairman, there is someone here to speak on this bill. I think they signed up to talk. I'm not sure.
Okay, okay, let me get to Chairman Kumar and let him see if he's got a question for you, and then if we need to go out and have the person speak, or what, you want your,
Thank you, Madam Chair, and thank you. We spoke briefly on the floor of the House, and I pulled you a copy of the Jacobson decision, but I didn't really get a response from you, and subsequently I tried to reach you. We haven't been able to connect. Life is busy, but is it proper for me to read the Jacobson decision as I have it, or shall we ask legal to do that?
as far as I think either one. So whatever's
Okay.
your preference.
In 1905 case, Jacobson versus Massachusetts, the Supreme Court ruled 7-2 to uphold a state's authority to require vaccinations. The Supreme Court ruled 7-2 to uphold state's authority to require vaccination. The case established that states can limit individual liberties to protect public health and safety. Thank you.
Okay, are you through with your questions, or you want to wait? Do you have a response?
Yes,
Okay.
You refer to the Jacobson decision. What I read is different from, I understand you're looking at it.
Okay, do you want to go out of session and
Oh,
let
sure.
your person?
And I can respond to that too. The difference is the non-delegation. What the Jacobson decision is looking at in that instance, in that part that you're reading, is that state legislature making the decision. This state legislature is not making a decision on individual vaccines. It is being delegated. But I do have someone here. If we could-
Okay, okay, we'll go out of session and ask for Andrew Tao. That's who's on our list that has sent in to speak. Is there an Andrew Tao here? Andrew's not here? Okay, he's the only one that is on the list. Let's see. Oh, well,
We do have verification of another person signing up to speak, Bernadette Pryor.
well, hold on just a moment. We've got to check here.
It was sent in and the bill was rolled, so it was from last.
If it was from a previous week. So hold on, we're getting
Okay.
the correct answer. Okay, so it wasn't on today's because it'd been on a previous one, but so Bernadette Pager. So come to the front and we're going to go out of session, and you need to state your name and who you're with, and you've got 2 minutes.
Okay, thank you so much. My name is Bernadette Pager, and I'm here representing myself. So I do agree with Representative Kumar that the landmark U.S. Supreme Court Jacobson v. Mass decision in 1905 established the constitutionality of state vaccination mandates as an exercise of police power, but while also defining its limits under the U.S. Constitution. The court affirmed that states have broad authority under their police power, a constitutional principle rooted in the 10th Amendment. However, this power isn't limited. It must be reasonable and not arbitrary. The ruling hinged on the mandate's rationality. In 1905, smallpox was a deadly contagious disease with a case mortality rate of up to 30%. The court did not rule on the science, the effectiveness, or the risks of the smallpox vaccine. The court deferred to the state legislature, saying they assumed that the legislature had done their due diligence and weighed all the evidence and approaches and theories before passing the mandate. The court said regarding the mandate, quote, that was for the legislative department to determine in the light of all the information it had or could obtain. It could not properly abdicate its function to guard the public health and safety, unquote. The same holds today. You, members of the General Assembly, cannot abdicate your function to guard the public health and safety to the CDC or the AAP or any other entity over which you do not have direct authority or control. Another milestone court decision happened in 2000 in Troxel v. Granville, and the court decided that, quote, the 14th Amendment's due process clause has a substantive component that provides heightened protection against government interference with certain fundamental rights and liberty interests. You, members of the General Assembly, enshrined that last year in the Families' Rights and Responsibilities Act. That act affirms that a government entity shall not substantially burden the fundamental rights of a parent unless it demonstrates that such a burden is required by a compelling governmental interest of the highest order and is the least restrictive means of furthering that interest. Right now,
Okay,
3710.
Your 2 minutes is way over. So,
Oh,
okay, at this time, I'll see if anybody on the committee has any questions for you, Bernadette. So stay right there. Stay right there. Does anybody have any questions right now while we're out of session to ask? Nobody? Okay. Thank you. Thank you for coming.
Thank
and we're back in session. Okay. Chairman Clemens has been asked, has got a question, so I'll recognize Chairman Clemens.
Thank you, Madam Chair. I appreciate it. I'm a little concerned about the casual dismissiveness of talking about just, will this result in a few kids not being vaccinated? And that's concerning. I mean, we're looking at children dying of measles in 2025. That's concerning. Children with tetanus, these types of issues. These are all concerning things that we should be cared about. If public health is a priority for us, I think we should be, our decisions should be rooted in fact and data. The reason that the Tennessee Code Annotated refers to the CDC and doesn't delegate, it refers to the CDC for the purpose of the vaccinations is because the CDC is the nation's leading science-based, data-driven service organization that protects the public's health. The state of Tennessee does not have that resource. The state of Tennessee does not have the resources to provide those services. There's a reason that we necessarily refer to and defer to the CDC for guidance on vaccinations. It's to protect the public health. Not vaccinating children is a threat of harm. The code is this way for a reason. I have sincere concerns with this legislation to the extent we're going to limit vaccinations, dissuade vaccinations, or somehow pretend that the CDC and what the CDC provides with science-based, data-driven information is irrelevant and should be ignored. That is a sincere concern of mine. And so, as a parent of 3 boys, every child in the state of Tennessee matters. To think that we would pass a law that would threaten the harm of one child is deeply, deeply concerning. And I think that's exactly what this legislation does. So thank you, Madam Chair. I have sincere concerns about this legislation. Thank you.
Mhm.
Thank you, Chairman Clemens. Next, we have Representative Cheryl. Well, okay. Do you want to respond for
Yes,
Okay.
thank
Sorry.
you very much. No one is saying that children should not get vaccinated. No one is saying that at all. What the point of the case was, is that the Supreme Court was assuming that the legislature had looked into each of the vaccines and found that they were safe and good for the people of their state. We have not looked into the CDC's ever-growing list of vaccinations, that ever-growing list vaccination schedule. We haven't looked into it at all. And so we are simply delegating all of our rights to the CDC, giving up everything to the CDC. And the non-delegation doctrine says that states can't do that. I have no doubt that when babies are born, because I have 6 grandchildren, but I have no doubt when babies are born, when they go in for their well visits, whether they go to a clinic or whether they go to a pediatrician, that the attending physician is saying, the CDC recommends these vaccines. Mom, Dad, I recommend them too. Can we vaccinate your baby today? Your child today? I have no doubt that will continue to happen. But when you look at other states who do not have this law, and you look at Tennessee, there's very little difference. We're in the middle of the pack. We're in the middle of the pack. So it's not that this law has made a huge jump. It is that this law does not follow the non-delegation doctrine. The committee is not, the legislature is not looking into each and every one of the recommendations, and that's just something we shouldn't delegate away. And don't forget to start daycare, preschool, or school in Tennessee. There is a vaccination schedule to start school in Tennessee. And with rare exception, some might have a medical waiver and some may have a religious waiver. With rare exception, it is followed.
Chairman Clemens, did you have a follow-up or anything that you wanted to say?
There are so many legal issues and factual issues with what was just said. I'll leave it at that.
Okay, next I have Representative Cheryl.
Thank you, Representative Lynn, for bringing this legislation. And I do fully support vaccines.
Yeah.
I believe there's maybe some concerns in it with different members and different ones. So I'd like to make a motion that we just roll this summer study and maybe look at it next year.
Okay, we have a motion and a second. Is everybody ready to vote on the motion? Okay, clerk, would you open the room? Okay, clerk, would you close the board and read the vote?
Madam Chair Lady, you have 10 ayes, 0 nays.
Okay, so Bill 1156 will move to summer study, and thank you.
Thank you, Madam Chairman. Thank you, committee
you.
members. Thank you.
Okay, next on our list is House Bill 0598 by Representative Freeman. Okay, so we have a motion and a second, and do you have any amendments?
I don't have any amendments I'd like to put on the bill.
Okay.
Thank you.
Okay, the bill is properly before us, so please proceed with your brief description of your bill.
Thank you. Thank you, Madam Chair and committee. So this bill deals with a tough subject matter, and it's what kind of freedom do we give people at their end of life? Not until the modern era did we not look at it as an honorable thing for someone at the end of life to end their pain and suffering. We afford that same right to our pets. This bill was brought out of a situation where I had a close friend whose father was diagnosed with terminal cancer. It was his third bout of of brain cancer. He fought it valiantly the first 2 times. The last time we went to the doctors and they said, there's really nothing we can do. And they were very honest and frank. And they said, the next several months are going to be really tough. And he was sent to hospice, in-home hospice, in horribly excruciating pain, unable to get out of bed. And his only solution to end the suffering and the pain was to stop his meds and stop eating. He had congenital heart failure. And to the doctors on this committee, he was taking a diuretic to remove the swelling. When he stopped that, his feet swelled up. That he again, the worst kind of pain you can ever imagine. He was a dear friend, and called me to his bed and said, please help me do something about this. Please help me, help people that come after me have an opportunity to choose dignity in death. And so what this bill does is there's a lot of pieces to it. It's very involved. It's modeled after multiple other states. There are 11 states that offer currently medical assistance in death. And it talks through how the process is that someone can ask for it. You have to verbally ask for it. You then have to receive a written request. It has to be notarized. Your attending physician has to agree that you are within your last 6 months of your life. There has to be a psychological evaluation to make sure that you're under no duress when you make the request, that you understand the consequences of your decision. You have to have a second doctor sign off on that. The whole process in other states takes several months, at which time the doctor prescribes some medicine, and you have to be able to physically take the medicine yourself. It's completely voluntary. Nobody is going to be forced to do this. It is very humane. Again, none of us are getting out of here alive. We are all going to deal with this at some point. Put yourself in that position. If you are at a point where medicine can no longer heal you, you're not getting up out of the bed, you're in horrible pain, would you not want at least the opportunity to have the conversation about ending your pain? And with that, I stand ready to answer any questions that the committee may have. And I fully recognize this is a tough subject matter that has a lot of nuances to it, and people have different feelings and beliefs, and I appreciate that. But anyway, thank you.
Thank you, Representative Freeman. Before we go, we do have some people to speak for the bill, and we have some people that are opposed to the bill. Before we go out of session to hear, does anyone on the committee have a question they want to ask? Okay. First, we're going to start with, we're going to go out of session, but I was just going to call up who we were going to do. We've got Katie Kelly. We've got a Dr. D. Joy Riley and a Stephen Puckett. Are they here today? Is it all three here? Okay. All right. We're going to go out of session, and if you three will just come down here and take your seat at the same time. And we'll see. So I know who Stephen is, but I don't know for sure which is who. Riley and Katie. Okay, if you want to, we'll start with you, Katie, first, and Riley, I'm sorry, and just state your name and who you're with, and then each of you will have 2 minutes, okay?
Thank you. Hello, thank you for having me. I'm D. Joy Riley, MD, the Executive Director of the Tennessee Center for Bioethics and Culture. I'm here to oppose HB 0598. I presume everyone here can agree that suicide is a horrible thing and produces long-lasting grief for those left behind. Because suicide is such a terrible tragedy, I'm at a loss as to why the state of Tennessee would want to involve more people in it. Medically assisted suicide, MAS, whether or not you call it that, is harmful. MAS harms patients by ending their lives. Vulnerable patients are at increased risk of being coerced or manipulated into accepting it. It may begin as a legal option, but become a social expectation. MAS harms society. It weakens our moral fabric because it decreases respect for human life. It medicalizes suicide and furthers the mistaken idea that suicide is a morally legitimate choice. There is some evidence that legalizing MAS increases suicides, both medically and non-medical. MAS can be used to reduce healthcare costs. Where it is illegal, some patients have received information that their treatment will not be covered, but physician-assisted suicide will be. While MAS may at first be legalized for terminally ill adults, experience reveals the scope gradually widens to include mental illness, people who are, quote, tired of life, and children. MAS harms physicians. Medicine is a helping profession. We don't amputate people's normal legs or arms because they ask us to. Why should we kill them if they ask it? Compassion literally means to suffer with. It doesn't mean kill the sufferer. Palliative care affirms life, views dying as a normal process, and does not hasten or postpone death. In contrast, medically assisted suicide is not healthcare. It reduces trust in the healing professions. After all, if your physician can either heal you or kill you, how are you going to trust what the medication he or she is prescribing will do? With this legislation, you may think that you can turn just a few healers into killers and everything will be just fine. It doesn't work that way. You weaken the moral fabric one thread at a
2
time,
minutes
and
is
the
over.
fabric is gone.
Okay.
Thank you.
Thank you very much. And next we'll hear from Katie. State your name and who you're with.
Good afternoon. My name is Katie Kelly. I'm a policy counsel attorney with Americans United for Life. Today I urge your opposition of House Bill 598. We feel nothing but compassion and heartache for these individuals experiencing potentially terminal diagnoses. But as we've seen in states where this has been legalized, it disproportionately impacts individuals with disabilities, vulnerable adults, the elderly, and individuals living in poverty. The data shows that the top 5 reasons that individuals choose, quote, medical aid in dying, does not even include pain management. It has to do more with fear of being a burden to their caregivers. And so we as a society should call our medical profession and call our caregivers to a higher standard when dealing with these potentially terminal diagnoses. And although the terms of this bill sound similar to the right to withdraw life-sustaining care, as I explained, it will disproportionately impact these individuals. Further, the bill does not actually include treatment options or require that treatment is offered for individuals who may be experiencing depression or grief associated with end-of-life diagnoses. And so, although a mental health and counseling referral is in the bill, the physician is only required to refer the patient if the physician has doubts as to the individual's mental capacity. That does not mean a physician must actually conduct an evaluation or any basic screening of the individual's current mental health status. And so this is extremely concerning. Is that time? Thank you.
Thank you, Katie. Okay, next we'll hear from Stephen Puckett. Tell us who you're with.
All right, I'm Stephen Puckett, and I'm from Hendersonville, Tennessee, and I'm speaking for myself and myself alone. I am speaking from a perspective of a pro-life Democrat. And the thing is, this legislation is, the reason why, what this legislation seeks to change is a Class D felony is because of the risk that's occurred. that occurs. I mean, the bill even recognizes the risk by citing that those who are caught violating will be subject to a Class A felony. But the reality is, there will be those who don't get caught, and we can't get back that life. We can't get back, we can't raise them from the dead. We can't get back that time. And, one of the things that a lot of people get confused about is that they look at, they see people who oppose things like this and they see, cruelty. The reality is we see both choices as cruel, the status quo and this legislation, because when we have a society that grades and demeans, and an economy that grades and demeans people to the point they see this as dignity, they see this as relief, that's the ultimate failure of us as a society. And and it's very, very similar to the abortion issue, in that we demand a better option. There it's a triage issue that we're looking at it as, where we want that confidence that every life that can be saved will be, that it's medically certified, there's an alternative, so the doctor knows what to do. But here it's much more nuanced, it's much more complex, because there are so many drivers, irreparable pain, and that's why I'm going to ask you to send this to TASER to look at those drivers. We don't even, we call ourselves a pro-life state, but we don't even plant the flag, set a goalpost and say, Wall Street, if you don't meet this, that percentage, your taxes are going up by the percentage that didn't. That's the challenge for you today, is to send this to TASER. Let's look at those drivers, because medical research, advancement, pain management. Let's get those drivers found and addressed, so that at the very least the sponsor has to work a little bit harder up there. It's like that man didn't break a sweat, and every Republican in this building started sweating as soon as they saw me here. So,
Oh, well, thank you for being here today, and thank you to all three of you all. While we are out of session, we're asking anyone if they've got any questions for any of our witnesses today. Dr. Kumar, you're recognized.
Thank you all of you for coming. It's a subject that touches all of our hearts, and we've known tragedies where this happened, and we have sympathy for them and prayer for them. My question to Ms. Kelly is that you mentioned that the reason for somebody seeking end to life when there is no hope for them was pain management was not the main subject or the top subject. I thought it was. And you said that the main reason was fear of abandonment. Can you elaborate what are the reasons people would choose to end their life?
Yes, thank you. So this is further described in my written testimony that's been submitted and emailed to everyone. But as far as off the top of my head that I can remember, data from Washington and Oregon, where this is legal, the top 5 reasons are fear of losing bodily autonomy, no longer being able to enjoy activities, losing bodily functions, and then fear of being a burden. And I'm trying to remember what the 5th one was, but pain management was not it.
I see. Well, thank you. Thank you.
Thank you.
Madam Chair.
Does anyone else have any questions before we go back? Okay. Chairman Terry.
Thank you. And I don't really have any questions. I just want to thank everybody for coming up and speaking and giving us your opinion on this. This is a very difficult topic for everybody to discuss. And it is, from a moral perspective, all ranges on this, and we're all touched by the suffering that's out there. But thank you guys for joining us.
Anyone else? Well, we're out of session. Okay. All right. Thank you all very much for being here, and we're back in session. And we will now go to Representative Freeman to see if this or, well, I thought we had some here in support, but that was for another bill. So I misspoke on that. So that is all we have in terms of witnesses today. So Representative Freeman, recognize you.
Thank you, Madam. Thank you, Madam Chair. And while those are sympathetic talking points, the facts just don't follow with the reality. The reality is that people that are suffering, these are real people with real suffering. It's not the mentally ill. It's not children. It's not the disabled. The slippery slope idea is almost laughable. We could pass a bill today to do that. There is no chipping away at this over time. If you look at the other states, they've not chipped away at it. They have not allowed for an expanse. It's not offered to children. Again, that's very sympathetic, but that's just not reality. Those are not facts. And the facts are that we have people in Tennessee that are suffering that are not going to get better. They're just not going to. At some point, medicine can no longer help. And do we believe in freedom and allowing people to have real dignity and a choice in how they want to end their days? Or do we get to pick it for them? Do we get to decide that they have to sit in that bed and suffer? Why do they not get the choice to make that decision for themselves? And the idea of suicide, don't even get me started. I have been personally affected by suicide, and this is nowhere near the same thing. The violence and the messiness and the force to clean it up after the fact that suicide gives, there's case after case of Tennesseans right now who are diagnosed with a terminal illness, and their only solution is suicide, is a violent, messy, uncomfortable process that they leave someone else to clean up because we don't afford them any other options in Tennessee. And I think that should change. And Chairman Terry, I do appreciate, this is a tough subject and it's extremely difficult and it's very nuanced, but let's continue the conversation and let's keep working towards a solution. Thank you.
Thank you, Representative Freeman. We have Representative Cheryl.
Thank you, Chairman. And Representative Freeman, I know you've went through a very tragic thing in your life and situation. This is a very serious topic that we're talking about, this legislation. In my opinion, it's a very dangerous thing that we are talking about taking a life, very dangerous. You know, to my understanding of what we read in the Bible, God gives life and God takes life. That's Bible, not us. A doctor, I'm going to say Dr. Kumar or Dr. Terry, and other doctors probably sitting out in here, they have a great responsibility to save a life instead of taking a life. I think that would be going against what they are sworn to do, to take a life. And that'd be the one that would be doing this, not me or you or whoever. It would be the doctor administrating what we're talking about doing. So I just feel like it's a very dangerous situation that we would be thinking about getting ourselves into if we were to do this. So thank you very much.
Representative Freeman, you're recognized.
Thank you, Chairman. Chairman, thank you for those comments. Just want to make sure and point out to the doctors in the room, this is permissive. No doctor will be forced to perform this service. And I would also push back a touch. People have advanced directives. People have DNRs. And doctors regularly will follow the patient's wishes and not revive them if they have a medical issue or their heart stops while they're in a procedure. So to me, this isn't new. Doctors already are allowing this to happen in our state. This is, to me, just including all the tools that we should allow for, again, more freedom for Tennesseans.
Okay, next we have on our list Chairman Kumar. You're recognized.
Oh, thank you. Thank you, Madam Chair. Representative Freeman, I have great admiration for you for bringing, as you said, a very difficult subject. And again, as has been mentioned, and you have said that also, the personal dimension that you have with the subject. Physicians or healthcare professionals or Tennesseans or church-going people, we are a sympathetic lot. In that sense, you feel sympathy for a person who's so unfortunate and to have reached a point in life that they would consider taking their life. But the other options for them are there, and it's not up to you and I to decide which is the best option for them. And how can any of us not be sympathetic to a person who's towards the end of life with no hope, maybe few months or so much time to live, and they're suffering because of pain or just disappointment with their fate. I've seen those people during my years of practice, and I think sympathy is instantly that it comes to you. Yet when they have talked to me about this possibility, I've taken a Hippocratic oath. And the oath comes into play, which clearly states that I will not practice or advise what we medically used to call euthanasia. So there is a obligation, and oath is taken to, well, the first words in the oath are, I swear by Apollo, which in 5000 BC was God. I swear to, God plays a big role in this whole dimension. And despite my sympathy towards that person that I'm dealing with, and yet we are struggling with the oath, or what Representative Cheryl said, God, life is a gift from God, and we have to respect that. Also, the misuse potential is great. We can tell somebody they have 6 months to live, yet we can be wrong. Yes, you have known that, and we have all known where the doctor told me I had so much time to live, and that was not the case. Given these uncertainties, to legally allow end of life, and again, considering the Hippocratic Oath, considering the gratefulness we have to God for this gift that is life, it just is not possible for me personally to vote for this. But again, I admire you for taking the effort. Thank you. Thank you, Madam Chair.
Thank you. And Representative Freeman, you recognized?
Yeah, thank you. Thank you, Chairman. Thank you, Chairman. Those were, I appreciate your words, and I have great respect for you as well. I just want to make sure and point out one comment that he said, and that is we are removing choices. And that's exactly what I think we would be doing if we don't allow for this to pass. We are removing choices from the patients to make a decision that they should have the freedom to make. And again, I fully appreciate the difficulty here and the moral dilemma, but I guess if someone has a DNR in their chart, do you disregard it?
You recognize, Chairman.
No, it is the law of the state, but DNR is different in that sense that a person already either has had a medical event in which they have died and their heart has stopped, and we will not resuscitate them. We will not start, ventilating them, pumping air into their lungs, or compressions of the chest, or give the electric shock to convert the heart rhythm. So those are the things that we will not do in a DNR, which is do not resuscitate situation. That is, a person has died or almost there, but we will not resuscitate them because they have made that choice. That is more of a passive act rather than active act. And the other situation that happens is a person who's on the ventilator has gone through surgery or other illness and have reached a point that we cannot maintain their body functions, whether it is the heart or the lungs. And there is no hope. They're not going to recover from it. And even being on the ventilator for them is suffering. At that situation, having watched them in that condition for a day or two or sometimes weeks, the family will make a decision and come to us and says, sorry to use the impersonal word, but pull the plug or go ahead and remove them from the ventilator. In my practice, in that situation, always we needed help. We needed help affirming that decision. and clergy was always involved, and a prayer to God was always involved. And we've gone through that. But I think that situation is not comparable to a choice of taking medications to end life.
Representative Freeman.
Thank you, Chairman. And I guess I'd respectfully disagree. I think that family members making a decision to turn off a ventilator is completely different than an individual making that decision for themselves. And while again, in the comments, he said that the person is not going to recover. This is exactly what this is meant for. This is meant for people that are not going to recover. These are people that are never going to get up and walk out of the room where they are living. That the only way they're going to go out of there is if they're carried out. And again, I think we should give and respect the freedom that Tennesseans have to make these decisions. And I believe, and we can parse the words and the actions any way we want, but we're already allowing this. But you have to get someone to such a critical level of pain and discomfort before we make those decisions. And then in many instances, the person themselves is not making the decision for themselves. We are allowing family members to decide whether or not they should carry on. And I fully contemplate and would expect that clergy would be advised at any step in this process up until the patient decides to take the pill. They don't have to do it. They can stop at any point. And if you look at the data from other states, there's a large percentage, more than half of the people who qualify for this program never go through with it. They decide they don't want to do it, or they decide that they're not ready, or whatever the reason. In some instances, because the process takes so long, they die before they get an opportunity to take it. And that's included in that number. But again, I fully appreciate this is a very difficult subject to wrap your head around, and there are a lot of emotions, feelings, but I really encourage everyone to give me a positive vote, and let's continue this conversation. Let's bring it to the full committee, and let's continue this conversation. With that, I ask for your support.
Okay. I think I've got Chairman Terry to speak next.
Thank you. And I appreciate you having this conversation. And you are correct. This is a very difficult. I appreciate the courage to come in front of us and speak this and share with what you have, because this is a very difficult discussion. And I don't think people. Maybe they do, maybe they don't. I mean, this committee, the bills that we hear in this committee have so many moral and ethical conflicts, and sometimes we have conflicts within our own minds on this. And I would encourage, and you've hit on a lot of great points, but I do want to encourage people at home, those in the audience. There's a book out there, The Righteous Mind, Jonathan Haidt, and he talks about moral foundations, and you hit on several of those, whether you knew it or not, in your presentation, and some of the folks that actually came up and spoke against it as well. Care harm is one, and what can we do to care for people in these types of situations, and are we doing what we can for that? Fairness. What is fair to our patients? And we're obviously still working through that as well. You mentioned freedom. Obviously people that come to my office know liberty is a big issue with me, and that's a conflict. And you did mention that in this. I'm not sure how authority and loyalty, those are a couple of the foundations, would fit in this. But the last foundation, and where it makes it really difficult for me, is sanctity. And as Chairman mentioned, within our profession, sanctity of the profession and sanctity of life are things that are very deeply ingrained in me. And so all the different emotions, all the different moral conflicts I share with you, but I can't resolve in my mind voting in the affirmative for this. But you're welcome to come up my office and we can have some discussions. So thank you.
Has anyone else got any questions for our sponsor? Okay, question has been called. Clerk, will you open the voting board, please? Okay, has everyone voted? And does anyone wish to change their vote? Okay, clerk, close the board and announce the vote, please.
Madam Chairlady, you have 2 ayes, 8 nays.
Okay, the House Bill 0598 fails.
Thank you, Chairman of the Committee.
Thank you. Okay, no one has any announcements on the committee? I will look forward to adjourn. Well, adjourn? We're adjourned.